Next, we have In re Shirazi, Evan B. Frank appearing for appellant, and Baruch Cohen appearing for appellee.
Good morning, Your Honors. Evan Frank on behalf of appellant Syed Jafar Jafari.
How much time would you like to reserve?
I'll reserve 3 minutes for rebuttal, please.
Thank you.
I have to begin this with several concessions in this case. I substituted into this case on August 31st, and at that time, I, as new counsel, should have reviewed the docket in its entirety. I should have discovered the July 29 warning, that was docket number 71, and I should have discovered the September 15th unified objection deadline. I should have obtained the dismissal motion as soon as I learned about it, and that was brought to my attention on October 20th. And I should have requested relief from the preserved deadline that the trial court told me of on October 28th. The preserved deadline for the opposition to that motion was October 29th, the very next day. I did not do those things. Those were attorney errors, and sanctions for those errors were warranted. The question, however, is whether the record in this case supports a permanent extinguishment of Mr. Jafari's claim.
So tell me, what is the standard of review?
Well, it's twofold, Your Honor. Under the Hinkson case, there's the choice of law, which the court correctly identified Malone. Could be argued that Henderson would apply, but the factors are the same. And then under the second prong of Hinkson, it would be the application of that law to the facts, and the choice of law would be de novo, and the application would be under an abuse of discretion.
And that's because he identified the factors and then he went and explained his position. So we don't substitute our judgment for his. We review to see if there's evidence in the record to support it, if his decision is implausible or impossible.
Understood, Your Honor.
Is that right? I mean, I'm right, correct?
Yes, and there is deference to Judge Clarkson's review. And
you also agree that 3 of the factors are irrelevant to this discussion. The only 2 factors are whether there's prejudice and whether dismissal was the least drastic sanction that it could be imposed.
No, Your Honor, that's not true. I question the first factor as well. That has to do with the expeditious litigation. And the
well,
reason...
wait a second. This case had been pending for more than 2 years by the time the case was dismissed, right?
That's true.
So it was not expeditious by any means.
No, but there is a causal analysis that needs to take place. The delay in the litigation, according to Docket 71, was bilateral. It cannot be attributed all to the plaintiff. And the OSC regarding sanctions in the amount of $5,000 was directed to both sides in this case. So while I agree that the public clearly has an interest in expeditious resolution, under PPA and Tukey and Lobert, causation does need to be considered.
So there's some blame that Mr. Shirazi has in the delay that was occasioned. Mr. Jafari is the one who has been who opposed this, who presented the claim, who is obligated to pursue the claim, who is the one that will suffer a problem if there's not a prosecution of the claim, not Mr. Shirazi. He doesn't ever want this case to be decided if he can prevent it, right? I mean,
correct.
that's you know that going in. So the burden's on Mr. Jafari to prove his case up, to do it timely, and to comply with the orders of the court, or suffer the consequences.
That's true. However, in this case, there is also, later on, there was a non-frivolous explanation for some of the delay and some of the shortcomings.
What is that non-frivolous excuse?
Former counsel, Nicholas Nassif, did submit a declaration showing that he, in his 80s, was going through severe medical issues that did result in emergency treatment and did ultimately result in my substitution into the case. At that point, the burden does shift to the defendant to show actual prejudice, and this would go to the responses to the request for admissions. It would go to the delayed or failure to file the joint statement regarding the evidentiary objections and the responses to the meet and confer efforts.
So let me just take you back to the beginning of your argument where you indicated that many of the problems that this court is now faced with and what Judge Clarkson was faced with your mistakes was your error. They had nothing to do with Mr. Nassif. It had everything to do with you. You didn't keep track of what the docket required. You didn't know that you were required to respond to a motion to dismiss. You didn't calendar the dates when pretrial statements or other stipulations required you to file documents. You didn't comply with the requirement that the response to the motion to dismiss was timely filed. You didn't indicate that you had the ECF privileges that were necessary that would have enabled you to be able to monitor more carefully this case. Those are all problems that fall on Mr. Jafari, not on Mr. Shirazi, and they're all attributable to your conduct.
I understand, and I understand that under Link they are attributed to Mr. Jafari as well. However, under Hill, we also have to look at, the impact and alternatives to a dismissal and, whether that choice of sanction actually conforms to the fault. And Your Honor, you are right that there are things that happened post the July 29 issuance of the warning, and I do think the analysis needs to be bifurcated to before July 29 and afterward when I took over the case. And I think
that doesn't mean we ignore what occurred before, does it?
Understood, but there was a delay caused by both sides, and that's expressly in the record, and it's not reflected in the order. And in assessing what happened after I took over the case, the court also should consider the actual prejudice that resulted. With respect to the motion to dismiss and the opposition, the late opposition, the fact remains that while the opposition was late, the motion was not. The motion hearing on the opposition was continued according to the October 28, I believe that was docket 110, and that was due to the longest government shutdown in history, and that was continued to January 20th. The opposition was filed on January 5th, and the appellee filed a full-throated reply on January 7th. The hearing went forward as scheduled on January 20th. The court issued a ruling on the day the hearing was previously scheduled. Judge Clarkson determined that oral argument was not necessary for the January 20th hearing. With respect to
But because isn't the critical issue not whether you timely filed a response, but the critical issue was that you didn't comply with the prior requirements, that you file stipulations by a specific date and that the joint pretrial statement be filed by a specific date? There was clear failure of performance, irrespective of all of the reasons that you might have given. You didn't seek an extension of time, you didn't come in and tell the court what the problems were, and you just didn't comply.
That's true, Your Honor. In the order, however, Judge Clarkson does reference the filing of the late opposition as proof of additional misconduct. So he does use that as part of his rationale in coming to his decision granting dismissal. With regard to the filing of the joint stipulation, again, this was an inherited deadline. It doesn't excuse it. I should have reviewed the docket, but it was an inherited deadline, and there was a transition of counsel due to the infirmity of prior counsel. And the pretrial conference was still scheduled for February 17th. So there was ample time between September 15th and the date of the pretrial conference that, notwithstanding my mistake and my responsibility, and it was my responsibility, and I do not shirk that responsibility, to check the docket and get up to speed as soon as possible on this case, there could have been a cure order, monetary sanctions imposed against me, or something, firm management, such that we could have ensured that the February 17th pretrial conference would have moved forward with the stipulated joint objections.
So it just sounds to me like what you're suggesting is that the court, this panel, should reevaluate what Judge Clarkson did and determine that you're more probably correct than he was in terms of his analysis. But that's not the standard, is it?
Yeah. If I could jump in there,
Sure,
I mean,
yeah.
you know, how do we come to a definite and firm conviction that it was clearly outside the acceptable range of sanctions?
Because lesser sanctions, the threat of lesser sanctions.
Let me make it a compound question too. Is there's always a lesser sanction than dismissal with prejudice. There always the possibility to say, I'll give you 2 more weeks or something like that. But at some point, cases are dismissed with prejudice. So at some point we get there. And how do we determine that? How do we get to having a definite and firm conviction that what Judge Clarkson did was clearly outside the acceptable range of sanctions?
Your Honor, lesser sanctions were never warned against me. They were never imposed at any point in the record in this case. And Judge Clarkson's analysis of whether lesser sanctions would have been appropriate doesn't address either of those factors. The lesser sanctions that were discussed were only discussed one time, and that was due expressly to delay caused by both counsels. And here, there is no evidence in the record whatsoever that any lesser sanction imposed against me personally would not have been effective. And there needs to be consideration of this fact. And that was absent in the order.
Do you want to reserve the rest of the time?
I'll reserve the rest of the time. Thank you, Your Honor.
May it please the court, Baruch Cohn for appellee Babak Shirazi. Appellant wants this court to focus on how the motion to dismiss arrived, but Judge Clarkson focused on what happened after it arrived, and the record supports Judge Clarkson. Even accepting appellant's version of the service dispute in full, this appeal turns on one question: what did the appellant do after his counsel learned that the motion existed? And the answer is absolutely nothing. Not an opposition, not a request for more time, not even a motion complaining about service. So the question for this panel is not whether service was perfect. It's whether Judge Clarkson abused his discretion in dismissing after actual notice, repeated warnings, and a documented pattern of noncompliance. And under the Hinkson case, he did not. And the actual notice changes everything. The motion to dismiss was filed on September 16th, 2025. By October 2025, appellant's counsel knew it existed. The October 28th, 2025 order continuing the hearing while preserving the opposition deadline. And whatever the service dispute, there is no dispute that actual notice occurred. And once it occurred, the focus properly shifted from service to conduct. And the ECF issue doesn't change the result. Even taking appellant's version of the ECF defect as true, the bankruptcy court knew about this issue and still found actual notice. And once notice existed, the question became whether counsel sought relief, an extension, or filed an opposition, and the record reflects nothing. The appellant did absolutely nothing after actual notice, not an opposition, not a request for more time, not even a motion complaining about service. Due process requires notice and an opportunity to be heard. Appellant received both. There was no prejudice to point to. This is a non-compliance case. It's not a missed deadline case. Judge Clarkson was evaluating the entire history of the adversary proceeding, repeated missed deadlines, discovery issues, scheduling problems, failures to comply with orders, and prior warnings. The dismissal was the product of a pattern that finally exhausted the court's patience, not based on one missed deadline.
So he wants us to focus some of the blame for this situation on your client's failure to comply with certain requests that occurred before the court entered its order saying if the plaintiff doesn't perform or fails to perform again, there'll be sanctions imposed.
I didn't hear the question.
I'm sorry. So the question is, to what extent do you think we have to look at what the debtor might have done or not done, as he's suggesting? How do we deal with that?
Because once the court issued an order with a warning and said if anyone, I believe he said if the plaintiff misses another deadline because prior deadlines were missed, the court will dismiss the case. At that point, the parties were relatively equal. It was before I entered the case. But at that point, there was shared blame. But once the court issued that order, it was pointed at one party's heart, and the dagger to the heart was to the plaintiff.
I'm going to ask you, a lot of discussion was about a lesser sanction, okay, a lesser result. Isn't the warning a lesser sanction than dismissing it at that point in time?
Well, warnings were given.
The whole idea of lesser sanctions or a lesser prejudicial order is to give people an opportunity to respond. I mean, in keeping with that analysis, isn't the warning that? I mean, hey, I'm giving you a chance. Tell me why I shouldn't dismiss this case.
I believe so. I think you're right. The warning is indeed the lesser sanction. And when the warning specifically says one more mess up, one more missed deadline, you're on probation, one more missed deadline after a series of many, I'm going to dismiss your case. That's the golden opportunity, the lesser sanction. Like you said, Your Honor, at one point of neglect on a case and blown statutes, does a trier of fact and a court of law have to say enough? And in this case, the court's patience was exhausted. And Judge Clarkson clearly followed Malone. The court expressly considered expeditious resolution, docket management, prejudice, the merits policy, the lesser sanctions. This was a reasoned evaluation of a lengthy pattern, not a rote checklist exercise. An appellant's argument is ultimately a request to reweigh the factors, but appellate review is not a second vote. Under Hinkson, the order must be affirmed. Hinkson ruled that an abuse of discretion exists only where the court applies the wrong legal rule or reaches a decision that is illogical, implausible, or without support in inferences that may be drawn from the facts in the record. The bankruptcy court here applied the correct standard, considered notice, prejudice, lesser sanctions, and the full history of the plaintiff's noncompliance, and applied Malone. Given actual notice to failure to seek relief after the notice, repeated warnings, and the broader pattern, the dismissal was neither illogical nor implausible nor unsupported by the record. This court's role is not to ask whether it would have reached the same result. It is to ask whether Judge Clarkson was allowed to reach it. In conclusion, this case was not dismissed because of a service defect. It was dismissed because despite actual notice, repeated opportunities, and repeated warnings, appellant repeatedly failed to comply with the bankruptcy court's orders. Appellant treats this as a service appeal. Judge Clarkson treated it as a non-compliance case, and the record supports Judge Clarkson. And for those reasons, Your Honor, appellee respectfully requests that the panel affirm. Thank you.
Thank you.
So, Your Honors, 3 quick points in rebuttal. The appellee argues that actual notice should supplant Rule 5, but it does not. Rule 5B1 requires service. Actual notice did not restore a full briefing period, and the dismissal motion and the late opposition caused no actual prejudice whatsoever because it was heard on the day it was scheduled. The appellee had an opportunity to file a full-throated reply 13 days before the hearing, and Judge Clarkson ruled on the motion. While Judge Clarkson's order is detailed, and it goes through all the Malone factors and discusses lesser sanctions, that level of detail still does not insulate the order from the record. And the record does not support that dismissal was the appropriate sanction in this case. The warning that came in July did not come as a result of plaintiff's unilateral behavior. It was bilateral, and it was not made to me. In substituting into the case, although I should have reviewed to the docket, the reality is I did not, and I was not aware of the warning at that time. I was focused on the fire that was going on with respect to the request for admissions responses that were 3 days late due to a calendaring error by prior counsel who served them 3 days late because he scheduled, according to state court rules, allowing for 3 days for service. And he was also in the hospital. And so I was busy with the 36B motion to try to withdraw those admissions because I knew that could result in a dispositive outcome against my client. And so the warning about the joint stipulation and court orders was not on my radar at the time. We were dealing with the dumpster fire that I inherited. And the meet and confers that are referenced in Judge Clarkson's order, the 9 meet and confers, the only ones of those meet and confers that were directed toward me had to do with collateral state court matters and none with the joint objections that needed to be filed. Nor was there an intentional refusal in this case like there was in Malone.
I'm sorry, but you're out of time.
I understand, Your Honor.
Thank you very much.
Thank you.
And we'll take this matter under advisement and issue a decision as quickly as we can.
Thank you, Your Honor.
Thank you. Thank you both.